Would Izzy really have gotten a dismissal on the very first episode of Lincoln Lawyer? Hi, my name's Greg. I've been a criminal law attorney for over 10 years, and today we're going to do an evaluation of Izzy Leto's case from the very first episode of Lincoln Lawyer. In order to do that, we have to watch the clip. So spend about 2 minutes watching the clip related to Izzy's case, and at the end, we're going to talk about it.
We had an emergency. My wife was attacked, for God's sake. She had a necklace violently snatched off her person.
That's what she stole?
At least your client has taste.
Anything you can tell me
I
about...
did not attack her. I snatched the necklace and ran. I did not attack her.
Okay. And is there a reason Jerry didn't try to plead this?
Because they wanted 2 years.
7, People versus Izzy Letts.
Mickey Holler, judge, asks that we approach. The risk of further antagonizing Mr. Holt. Maybe we could call him up for the sidebar?
Mr. Holt, could you approach the bench, please?
I'll make this quick. Now, my client is charged with grand theft, which under Section 487 of the Penal Code means the value of the stolen object exceeds $950. Your Honor, that necklace is worth what? 400 tops?
What?
Yeah, I've taken more than a few payments in diamonds and gold, developed a pretty good eye. But to be sure, Judge, I also brought with me an expert on the matter who can give us a pretty quick appraisal. I realize the district attorney might want to get one of her own. I'm guessing your wife doesn't know it's a knockoff.
Hold on. Even if it is a knockoff, the defendant thought she was stealing the real thing.
You have a witness to testify as to her state of mind?
Did you not have the necklace appraised?
We have the appraisal from his insurance company.
Which might open up a whole new can of fraud. I could be wrong, of course.
Miss Shepard, any thoughts on how you might like to play this?
Completely dismissed? I get to just go.
Well, unless the DA decides to prosecute the Holts and you get called as a witness against them, but I don't think that's going to happen.
So the first thing that I find really interesting about this particular clip is how the case was charged. The prosecutor in this case charged a grand theft under Penal Code Section 487. But as a prosecutor, I would never actually pursue a 487 on this case. I would absolutely have charged this as a robbery. And there are a few reasons for that. The first big reason you want to charge a robbery is that it's in fact the easiest charge to prove in this case. To prove a 487, Mickey Holler has it right. You have to prove that the value of the item was greater than $950. But for a robbery, you don't have to prove the value at all. Instead, what the prosecutor has to prove for a robbery is that the defendant took property that's not their own, that they took it from the possession of another person, that they took it from that person's actual person or from their immediate presence, that they took it against the victim's will, and they took it using either fear or force. Now here, snatching a necklace is force, whether it's done violently or not. There's a case that came out in 2021 called People v. Gonzalez, where the California courts looked at whether snatching a necklace off of somebody's neck is in fact the force required for a robbery. And the court concluded, of course, that it is, because people don't ordinarily take their own necklaces off by breaking the chains. And in the process of breaking the chain to pull a necklace off of somebody, that is the force required for a robbery. So in this case, if Izzy snatched the necklace off of Mrs. Holt's neck, then that's a robbery. And I would absolutely charge a robbery. The second reason you want to charge a robbery is that the overall sentencing structure is higher for a robbery. A robbery's sentencing structure has an upper term of 5 years, a middle term of 3 years, and a lower term of 2 years. And you could give somebody probation for a robbery. A grand theft, on the other hand, has an overall lower sentencing structure. There's 3 years as the upper term, middle term of 2 years, 16 months for the low term, and then you could also possibly give probation. If you charged a robbery in this case under Penal Code Section 211, you could make a plea deal to have the defendant plead to a grand theft under 487. There are a lot of advantages for the defendant in that. One being that robbery in California is a strike. That's significant for a few reasons. The most important reason is that in the future, if Izzy commits any other felony in California, a prior robbery conviction would automatically double her sentence in future cases. And if she had to admit to the prior conviction for a robbery, she would be ineligible for probation and she would be sentenced at the minimum to the low term doubled on any other felony that she would be convicted of in the state of California. That sort of doubling would not occur if she pled to a grand theft under Penal Code Section 487. In this case, Izzy was originally offered 2 years by the DA on the 487, which is midterm. And what that tells me is that she has a substantial criminal record. In California, on a very first offense like this, I would suspect that if it pled for a felony, and it could plead for a misdemeanor, if it pled for a felony, the very strong likelihood is that it would be a probationary sentence, would not be low term, and it certainly would not be midterm for a first offense. What that tells me is that Izzy has a prior criminal history. And that's all the more reason a prosecutor would be likely to pursue a robbery as compared to a grand theft under Penal Code Section 487. The second issue that I see in this case is that while Mickey Holler, he makes a great argument about the value of this necklace being under $950. The problem, though, is even if the prosecutor was just pursuing a grand theft, the fact that the necklace was worth less than $950 would not result in a dismissal. Instead, what would happen is the prosecutor would, in that case, offer a misdemeanor for a petty theft to Izzy, and likely that would have resolved the case. If Izzy still said, I want to go forward with the trial, this was a court trial, the prosecutor does not have to prove the value of the necklace for a petty theft. So what the prosecutor would do is simply call Mrs. Holt, say, I had this necklace, Izzy snatched the necklace, it happened here in Los Angeles County, and as a court trial, there is an extremely substantial likelihood the judge would find the defendant did in fact commit a petty theft, and she would be convicted of at least a misdemeanor. If you enjoyed this evaluation of the very first episode of Lincoln Lawyer in Izzy Leto's case, please subscribe. In the future, I plan to do additional evaluations of other cases that Mickey Holler handles on the Lincoln Lawyer, and whether they're accurate or not accurate under California law, and what sort of issues I see in them. And if you have suggestions for other shows that I could evaluate or you would like to see evaluated, please drop something in the comments.